Welcome tonight on Politics HQ News Central TV. A recent ruling by Nigeria's Supreme Court has put an end to the People's Democratic Party's attempt to remove Governor Uzodinma of Imo State from office as a governor of that state. Like we said, the dismissal of the application, coupled with the imposition of fines on the PDP's council, Ozekhome, SAN, has sparked a heated debate. Well, tonight, let's dive into the intricacies of this legal battle, and let's also explore the implications it holds for Imo State politics and also Nigerian politics. I'm glad to say we have as guest a legal practitioner of no mean repute. He joins us via video link in Lagos, Nigeria's commercial nerve center. We have also, his name is Ubani. We have also another lawyer, Emeka Ihedioha, who's a spokesman for the Senator Ethan Achono campaign organization, and of course, the Labour Party's legal advisor in Imo State. Gentlemen, thank you so much for your time.
Thank you for having me.
All right. Ubani, the Supreme Court dismissed the PDP's application. Of course, we all know what transpired with Imo State as far as the governorship election there was concerned, hotly contested. And that application by the People's Democratic Party was meant to remove Uzodinma, and the court stated that the matter lacked merit and jurisdiction. What exactly does this mean, and what is your thought or your take on it?
Thank you very much. I also read the news the way you read it in the newspaper tonight of what transpired at the Supreme Court today concerning the attempt that the PDP was making in order to remove Uzodinma. Of his first tenure, it's not even the second tenure now, even though they alluded to it that if he did not win the first tenure, ordinarily and normally and automatically, he is also not qualified to have contested for the second and wouldn't be the governor even in the second tenure. Now, this is the particular matter that was started by Judicial, who was saying, look, if the Supreme Court eventually said that he was the candidate of APC and the candidate of another political party, that's AA, he was not qualified. PDP now wanted to catch in on that to say, look, as at the time that Uzodinma purportedly won the election or declared the winner by the Supreme Court, he wasn't the proper candidate of APC, because the Supreme Court had earlier on in the pre-election issue recognized Uzodinma also as a candidate of APC, and that is the ground under which they eventually joined. Now, that case has been lingering on for some time now at the Supreme Court level, and eventually it ended today. It was terminated. Now, the Supreme Court was of the opinion that the action is clearly frivolous, and you can also see the anger in the damages that have been awarded against the lawyer, the counsel, the senior advocate of Nigeria, that's Ozekhome, who handled this matter on behalf of PDP. The Supreme Court was clearly angry that this matter shouldn't have been brought before the Supreme Court, because every matter that has to do with Imo gubernatorial election should have ended a long time ago. This is a man that had already exhausted the tenure of 4 years, and you are asking that he be removed, and you are bringing a pre-election issue after how many years? Pre-election issue under our constitution has a timeline, I think 14 days, within which to commence that action. I don't think that PDP commenced that action within 14 days after whatever they're complaining about, had happened. So this is a matter that eventually joined as a party, as an interested party, who, according to them, would be a beneficiary of that judgment if it eventually goes against Uzodinma. So the Supreme Court was feeling that clearly the Supreme Court has no jurisdiction over this matter. This is a matter that shouldn't have been brought, because it's like you're asking the Supreme Court to review or sit and appeal over his own matter and all that. I think that is anger. We have not seen the full reason that the Supreme Court gave, especially with regards to that led to the award of damages against the lawyer personally. But I think that the Supreme Court felt that there must be an end to litigation. We should actually come to an end in litigating over electoral issues. The way we are burdening the court, everyone is getting concerned with the level of litigation, by Nigerian politicians.
Okay, Ubani, This you're saying is, should long have ended before now. The election has come and gone. We're looking at those petitions and cases that have to do with the substance of the last election, which was held recently. Is there a similarity between this and the recent case taken to the court against the presidency of Bola Tinubu, which I think is at the Supreme Court, where the applicants are saying that he should not have been sworn in while the litigation was on? Because it could be argued that Bola Tinubu has already been sworn in, he's been taken to the Supreme Court, all the petitions have been addressed, and we have to move forward from here.
Yeah, that's what we're saying. And there are some cases that I think that some of our lawyers, our counsel should not anyway be burdening our judiciary with. Now, the person who has gone to court arguing that the current president shouldn't have been sworn in, under what law presently is he coming under? Under what? Is there any law, either Electoral Act or the Constitution, that says if a president has been announced and that he should not be sworn in until all the cases concerning his election has been exhausted? There is no such law presently in existence. Apart from trying, I would say, playing to the gallery, there is no such law. Let's be sincere. I'm not against people going to court in order to ventilate their grievances, but we must be very careful. Some of the reasons that makes us to go to court, we must have solid ground, legal ground for us to go to court, so that we don't make the court to be a jesting. It's not a jesting ground. It's not a comedy ground. It is a court of justice, where serious issues concerning people's grievances are addressed. But if you begin to carry every matter that has no legal basis, that no factual basis, you are ridiculing the judicial system and making it look as if the judiciary will begin to do something that is clearly impossible. There is no law. As I speak to you today, there is no provision in the Electoral Act, either in the Constitution or any other act, that says the president of the country, once announced, should not be sworn in. But what we're saying is that we can't change our law to ensure that before any of the elected political officers, office holders are sworn in, let there be exhaustion of all the litigation process, so that the person does not use the wealth or the fund of the masses or the taxpayers' money in order to fund the electoral process. That's one of the things we are clamoring for. There should be a change to that. But before that change is done, it is clearly wrong for any counsel to advise a client to go to court and say that the president shouldn't have been sworn in. Okay. But there is no law.
All right.
Presently.
We'll come back to the matter of the lawyers and how they get these cases into court. But Ubani, your colleague was the counsel for the PDP, Michael Ozekhome SAN. He's been quite busy with a number of election-related cases. What are your thoughts on the imposition of that 40 million naira fine on him as PDP counsel? It's drawn a lot of attention, and people are commenting on it. Now, what are your thoughts or your take on that?
What the Supreme Court is trying to say with regards to that fine that has been imposed on him is that lawyers should, at every point in time, look holistically all the cases they bring before the court, especially before the Supreme Court. If it does not have any merit whatsoever, they should be in a position to advise their clients not to pursue this matter. What the court is now trying to send a signal is that, look, if you advise your client to go and come to the court in order to ventilate over a grievance that does not have any legal basis, we're not only going to award cost against the client or the defendant or the appellant, but we'll award that particular cost against the lawyer who ordinarily should have advised against it, but probably advised that the matter should go further, proceed to court, and then have the boldness and to bring it before the court. So that's what they're trying to send signal with the recent this particular award of fine that has been made against the learned sick and all that. So every other frivolous appeals, they are trying to say that shouldn't be. We are overburdening our judicial system by some of the cases we bring before the court. So that's what I think about it. I'm not going to make any condemnation against Mike. Maybe his client, but what we're saying that from now onwards, can we begin to advise our client over certain cases that shouldn't go to court, especially on appeal to Supreme Court?
Okay,
if it does not have any merit,
but Ubani, 40 million naira. I mean, some human rights cases of death, people are killed, some people are brutalized. I mean, personally, I had a case of a human fundamental rights enforcement case. Went to the court. I got 5 million naira. This is a fine imposed on a lawyer to the tune of 40 million naira. Are you concerned about the amount and the message that amount may pass?
Yes, I'm a bit concerned. The amount is a whopping sum of 40 million, even though our naira doesn't have much value. 40 million naira at this point of time in our national life is not a small sum. It's not 40,000 naira. It's not 40 naira. It is 40 million that has been imposed as a fine. I think there's no further appeal over this matter. I think that the Supreme Court justices might have used this particular case to send a strong signal. That's what I think. That's my thinking. But I don't know whether it is a question of using a hammer now to kill a fly. But it is a bit heavy. It's a heavy sum. It's a heavy sum, honestly. But I think it is the punitive idea behind it that made this particular sum, to have been very much, because the court felt that, look, we have dealt with this matter. This man has been in government for almost 4 years, and you are still coming in to challenge that he should be, removed out of government. How practical it is, and in a pre-election issue, and more so when this other man, that is the man that is now wanting the court to remove Hope Uzodinma, has finally decided the matter in the Supreme Court between him and Hope Uzodinma, saying that Hope Uzodinma clearly won the election. That's what the Supreme Court said. So that case was decided, in which Hope, was, declared a winner, and he that is coming through the back door now was said not to have won the election. So coming back, to now ask the court to remove Hope Uzodinma is clearly like reviewing the decision of the Supreme Court. And the Supreme Court felt that the lawyer should have advised the client not to have probably engaged in this particular journey. That's why the heaviness of the penalty. My Chief Mike Ozekhome is my personal lawyer. It's somebody I have so much regard and respect for, but I'm clearly not too happy for this kind of fine that has been imposed on him. He's a very intelligent lawyer. He has won many landmark cases. Chief Mike Ozekhome is a very brilliant lawyer. Everyone knows.
We will agree with you, Ubani. He is a brilliant lawyer, but re-litigation of already settled cases, to the point that the court will use the words frivolous and vexatious. I'm sure that. Yes. How does a lawyer, not see this and the problem ahead, the danger ahead? When you're on the road and maybe there's a pothole somewhere, or they are constructing something somewhere, they'll tell you, slow down, danger ahead. So yes. Is it that lawyers are not allowed to advise their clients, say, oh boy, this thing, go fly, or make we rest on my back. God done, litigate on that.
Yeah, you're very correct. There are some the clients will advise and they still want you to go ahead. Now, let me say this. Before now, the Supreme Court has been entertaining all manner of cases, and that is the truth. But recently, if you are a person that attends the Supreme Court, if you attend Supreme Court recently, you can see their demeanor, you can see their body language, that they are no longer interested in entertaining any frivolous matter, especially political cases, because one, he has brought a lot of bad name to the judicial system. And then secondly, they are overburdening the judiciary. These guys don't sleep. And reading these things is not easy. So when they now see that you are coming over a matter that has no basis in law, no factual basis for you to have come in the first place, they feel anger that, look, you guys are ridiculing the judiciary. I think that is the thing I want to say, because if you are a president, if you go to Supreme Court recently, you see their body language, will understand that they are becoming irritated with all manner of cases now that people are bringing. Even when those cases are settled, it's a settled precedent, and people still want to come and test, their will and all that. The Supreme Court is now sending a line language through their body system. Look, we don't want all this overburdening of that we're going to be imposing, not necessarily against the client that come or their appellant, but against the lawyers that actually bring these cases. So it will now make lawyers now to sit up and know some of the cases they should want to go upstairs, because everyone wants to go upstairs. And some of us also know the reason why this upstairs, it has become a thing that is of excitement for many lawyers and all that. But they are now saying, look, if you don't have any basis in coming to the Supreme Court, don't bother, because if you do, and you feel that you have a base for it, and we find out that there is no basis for it, we will impose a very punitive fine on you, not on the client, but on you, the lawyer who have advised them to come. So I'm saying that I'm very sorry for what has happened to Chief Mike. He's a brilliant lawyer, as I said earlier. He has won many landmark cases in this country and all that. But I'm sure over this particular one, he must have inspired that. You can see the penalty that has been imposed and all that. So I sympathize with him. As I said earlier, he's my personal lawyer, very intelligent man that I always respect, and he's highly respected by even the justices of the Supreme Court. But they felt over this particular one that he should have advised his client not to have further coming before the Supreme Court.
All right. Thank you, Ubani. Ihedioha is a lawyer and is also the spokesperson for one of the governorship candidates in the recently concluded Imo State governorship elections. I'm talking about the 8th National Campaign Organization. He's also legal practitioner, legal advisor, rather, of the Labour Party in Imo State. Ihedioha, thank you very much for your time. What's your view? You're a lawyer, not just a spokes or representative for the former governorship candidate or governorship candidate, but you're a lawyer. What's your take on this matter that the court has described as frivolous and vexatious and an already settled matter that should not have been relitigated? Ihedioha, are you there? All right. While we try to reestablish connection with Ihedioha, let's go over to Ubani. Ubani, is there no judicial precedent as far as relitigation of already settled matters are concerned? Because, if the Supreme Court is saying don't bring such a matter to us, have they not dabbled in this arena, in this area, in this, sort of action before? I mean, we can look at probably the new Naira note saga. It's the most recent one.
Yes. Let me say this, when a matter has been finally decided by the Supreme Court, which is the final court in the land, you don't come back to the Supreme Court for the Supreme Court to review his decision, by way of appeal. You can bring a matter before the Supreme Court on a different matter entirely, different subject matter. The Naira stuff you mentioned now is now talking about Supreme Court making a decision that this is a deadline, and somebody is now finding out that deadline cannot, be able to be made in the light of present economic situation or financial situation in the country and all that. Then it comes back for the Supreme Court to look at that matter and probably make a decision. That is different from a matter that has been concluded and decided with. I mentioned that Uzodinma and the former governor who was under PDP, who presently now want to remove Hope, had their matter finally decided by the Supreme Court, in which Supreme Court pronounced Hope Uzodinma as the winner, and has been sworn in how many years ago? So coming now through the back door, because this is like a pre-election issue. Let me find out. Did he start this pre-election issue from the beginning? He came in as a party. And by the time he came in as a party, the 14 days deadline for pre-election issue, has it not elapsed? There are many issues the Supreme Court would have taken into consideration in this matter. And this is a man that have exhausted his tenure. Would it be better to come and begin to try your luck through that method when in the Supreme Court had decided the matter between these two parties? These two parties' matter has been decided by the Supreme Court. And you are now coming back that you now want to be sworn in that Hope Uzodinma and all that. The court is not a just.
But if there are fresh evidence, fresh findings, fresh facts that might influence a different, judgment or verdict by the Supreme Court, can they be brought before the courts again?
The problem with that is that election petition or election matters are sui generis. They are a special kind of a case. And then our laws have made a particular provision for deadlines. There are deadlines. So if it says you have 60 days, you have 180 days, you have this number of 14 days within which to really express your grievance over electoral dispute or electoral matter, that particular deadline must be complied with. It cannot be extended. It's like the law of Gibraltar, and make this media that cannot be. You cannot extend that law. There is not even the leave of the court cannot be sought in order to extend that deadline. So what I'm saying is, since it's sui generis, there is timeline within which to ventilate whatever grievance you have about electoral issue. The moment that timeline is passed, you don't come again and say, "Oh, you have fresh evidence," and you now want to know. They will not listen to you because the timeline has passed. The court has no jurisdiction, and jurisdiction is a very critical issue in adjudication. If it does not exist, it does not exist. If the court does not have jurisdiction over a matter, there is no way you can confer jurisdiction upon that court because there are issues that give jurisdiction to a court. If it doesn't have it, it doesn't have it. It's a foundational issue.
Okay.
It's a critical issue in deciding a matter. If it's not there, it's not there. You can't put something on nothing and expect that thing to stand. So that is actually what is going on. So if you have evidence you are now bringing in which you consider fresh, you have to consider the timeline within which you have brought that particular fresh evidence. If the timeline has elapsed, then you cannot smuggle it in. The court will not allow it because the court has no jurisdiction. That is actually what goes on with election issue, petition issue.
Interesting. What about Ubani? Do you see this statement, this huge statement by the Supreme Court, not just talking about imposition of fines on the applicants or the plaintiffs, but also on their lawyer, heavy fine, 40 million naira. Do you see this passing a message strong enough to ensure, to make your colleagues in the legal profession say, you know what, hold up, we can't go to court on this matter, because we don't want to incur the wrath of the court. Let's stay action. You see anything?
Yeah, what happens is that, it is actually the NBA that should be able to be doing things like this, But if NBA is not living up to expectation in ensuring that only cases that are worth insult, goes to court, maybe the court now, through this method, is now saying, look, if you can't do you can't put your house in order, we will be able to be doing it this way, that if anyone brings any matter that is clearly frivolous, especially these political cases, that comes to overburden the judiciary and put us on our age with all the bad names we are being called, even despite all our efforts, to do justice in this country. Every day we are being battered and we are being buffeted. So we will now begin to take a pound of flesh, from you guys who are really creating this crisis. Yes, that's what I think. So we'll be taking our pound of flesh, because we don't have any other way we can express we don't talk to the press. We don't express our burden, to the press. They are silent. We speak on their behalf, lawyers too. So, but if you guys cannot put your house in order, what we do now is that we're doing these things by imposing such punitive measures on lawyers in order to send very strong signals. So I think that, it will go a long way. For any lawyer now to go to Supreme Court, you have to look at the cases, look at the possibility, look at any precedent with which you can really go to court and convince the court that the court should look into it and all that. But at the same time, I'm also saying that the court should also be mindful of the fact that they are not shutting people out. It's important we balance it, because there is no other place you can go to, sir, except the judiciary or except the court.
All right.
You can't carry knife, you can't carry gun and go to any place in order to express whatever is your grievance, except the court. So the court must also be very, very careful not to now use, fines in order to drive away a prospective litigant before the court. Must balance it.
I think that's a sound bite right there by you, Ubani. Well, it remains to be seen if the political parties and their legal counsels will, draw any lessons from this dismissal and fines imposed by the Supreme Court. But we will keep our eyes on this and see where the conversation takes us. Ubani, thank you very much for joining us. Always, as usual, sterling analysis from you. We appreciate it.
Thank you very much for having me. Good evening.